All right, Mr. Froelich, we found your client. I think it's taking him, I don't know, 10 minutes to walk from the back, which I don't understand why it's taking so long to walk into the courtroom. All right, Jacqueline Lamerson. Yes.
I'm here. Oh,
That's what you're here for.
I was recalled on David Perez from yesterday.
Oh, well, he needs to come up here. Okay, yeah, we're gonna take his matter up, and then we're gonna bring the jury in. All right, what is happening with David Pettis? It shows that he was recently restored.
He was not recently restored. He tried to do the mental health court PTD, they
That's one second, I have the,
have discharged him from the program. So now he's back. And a previous attorney had had him prior to mental health court. So now I'm also I'm likewise starting at the beginning of this case for me as well.
all right, is this criminal trial division or family? Appears to be it's criminal trial division. I'll send you to a breakout room to confer.
Thank you, Judge. Judge, could you make me a co-host so I can go in and out?
Yes. And Mr. Grimm, if you'll send her to a breakout room, please.
Will do.
Take up Mr. Medellin. Mr. Villarreal, are you able to take the plea on Medellin?
Yes, Your Honor.
And Ms. Ferguson has put in the chat box that I guess we're starting on BARRIUS, is that correct?
Yeah, she's the first one.
I thought we were.
Okay, all right, thank you.
You.
All right, court is calling 2021 CR 10541, State of Texas versus Mario Medellin. Can I have parties announced for the record, please, for the state,
Michael Villarreal for the state.
for the defense?
Andrew Freilich for Mr. Medellin.
All right, we're proceeding by video. Because of the pandemic, however, Mr. Medellin is in the courtroom because he decided to smoke on Zoom, lay down on Zoom, and eat on Zoom. So any objections to us proceeding by video? Defense?
No objections to the defense. Judge.
State?
None for the state, Your Honor.
Mr. Medellin, I'm showing you what's entitled defendant's consent to appear by video. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
All right, court will find that the defendant has knowingly and voluntarily consented to appear by video. Showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I believe we have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Medellin, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
I believe so, Your Honor.
Yes, you are.
Thank you, Judge.
Mr. Medellin, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with forgery of a commercial instrument? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and
Yes,
up to a $10,000 fine. Did you understand?
yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes,
Did you understand by entering this plea bargain agreement, you were giving up those rights?
yes,
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
yes, Your Honor.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Has he provided any defenses?
Has
Yes.
he been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Medellin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, I did.
According to the plea bargain agreement, there's a $1,500 fine. State recommends deferred adjudication. They will take in consideration night mag number 647566, and there's to be restitution, if any, to Jack Kelly, Kelly. Did you understand that to be the plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, Your Honor. I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be no contact with Jack Kelly and Cats 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
Yes, Your Honor. At this time, state offers state exhibit number 1 and its attachments.
Any
No
objection?
objection.
Mr. Medellin, I'm showing you what's entitled waiver and consent to stipulations of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
All right, if we could go off the record for a moment, please. Deputy Voir, can I have it? All right, Mr. Frolick, I put something in the chat box to you. My understanding they're remedying that situation as we speak.
Oh,
Are you? Yes. So I have it in the chat box to you.
no objections, Your Honor. Thank you for letting me know.
Sure. Mr. Callahan, you have Mr. Watson. Do you need to speak with Mr. Watson or you need to confer?
With the prosecutor, please, Judge.
All right, thank you. Just give me one moment. Let me add to your name. This is criminal trial division, correct?
Yes, ma'am.
All right, I'm going to send you to breakout room number 2.
Thank you.
James Meyer,
Yes, do we have Mr. Jesse Perez available? in
Just
custody?
one moment. We will make sure, I'm gonna send you to breakout room. And I'm gonna send you to a breakout room with Miss Ferguson. And they'll make sure that they have your party with you. Oh, there you go. You need Pettis online. All right. I'll send you to a breakout room, number 3.
Thank you.
Jar Chairman, Mr. Lawrence. Jar Chairman.
I think he just stepped out, Your Honor.
Thank you. How long the party's gonna need for, Mr. Kalfas, how long do you need for, Portier?
Let me ask Sergio Judge, just because he's the one that's gonna do it. I think probably just, what do you standardly or normally do?
Well, I just see how much you all are asking for, and then if it's reasonable, then that's what we will do.
It'll probably be reasonable, but let me ask you.
Okay, all right.
I don't anticipate any lengthy period.
Thank you. All right, thank you.
Judge, can we excuse our second client, or do you want to vote here?
Just give us a moment.
Okay.
Mr. Froelich, I sent you a chat.
Thank you for letting me know. I am looking at this right now.
All right, Mr. Froelich.
Yes, Your Honor.
All right, that issue has been corrected.
Okay.
All right, we're back on the record in 2021 CR 10541. The court has accepted into evidence states exhibits 1 and attachments. And the court is reviewing the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
One thing that wasn't included in the plea bargain that I want to make sure gets on the record, we intended this would take care of 2 cases, one of which was filed in error.
All right, is that NIMAG number 647566?
That is the first one, Judge. The second one is going to be 2021 CR 4509.
All right, just one moment.
I just want to make sure that makes, and everything else, Judge, we asked you to just follow the plea bargain.
And Judge, that's correct. That case should already be dismissed.
All right.
It's still showing in the system of climate. And the last thing, Judge, my client is appointed, so we'd ask for the lowest court costs and fees that the court can adjust for those.
All right, where are you employed, Mr. Medellin?
I'm unemployed, ma'am. I've been unemployed for the past 2 years.
Why?
My license has been on hold. I'm an electrician. My license has been on hold from the Attorney General.
For child support?
Yes, ma'am.
All right, so then you're not paying your child support and you're not working. Why don't you do something else?
Well, it's hard for me to go from, I was making $34 an hour to go to just do something. I mean,
Do you love your children?
I love them dearly.
Your children need to eat. So there is no pride that should stand in the way. So whether you're going from $34 to $5 an hour, your children need to eat. So right now, if your children were solely dependent on you for food, they're starving. So your license has been suspended because you're not paying your child support and you're not working because you don't want to make less than $34 an hour. You're in a quandary.
It's hard for me to get. Everybody tells me I'm overqualified, and
No, McDonald's and everybody is hiring. So
I
how are
understand.
you eating?
I've been suffering. I've been homeless.
No, how are you eating? You're not 10 pounds. What have you been eating?
I was a lot heavier than this, Your Honor, and I barely started staying my sister's in.
No, but what are you eating? Are you eating daily?
Not on a day, I don't eat 3 meals a day. I know I don't, Your Honor.
How many meals a day do you eat?
Maybe 2.
All right, so if your children were solely dependent on you, you know how many meals they're eating? None. So how are you surviving if you don't have a job?
Do what I can. I bum off of other people, Your Honor.
No, you're gonna get a job.
I'm trying to.
And let me just tell you, McDonald's is hiring, and McDonald's is not gonna say, we don't want you working fries because you're overqualified. They're gonna accept you. Burger King is hiring. When you have children and you're depending, and other people are depending on you, you need to knock your pride aside because your children need to eat.
I understand, Your Honor, but I have literally been told that I'm overqualified.
Have you tried McDonald's?
I haven't tried McDonald's.
There
but
you
I've
go.
tried
So
other places
McDonald's
just
has
like
not told you you're overqualified. You need to get a job. You have children to support. How many children do you have?
2.
All right, so they need to eat and they need clothes for school. You understand?
Yes, Your Honor.
And you're not providing that for them. And you and I know the reason why your license is suspended is because you haven't paid child support. So when you were making $34 an hour, you were not paying your child support.
I was paying child support. It's just that when I got hired full time I went from a temp agency to a full time, and it was a company out of Colorado that was not sending the payments for my child support. And when I was there to finish the job, I was doing. I was running a job out in Bernie.
Well, you know what that means? That means that you haven't been in contact with your children, because if you were in contact with your children, the mother of your children would tell you, I haven't been receiving child support. So
Well-
all of this is back on you. So again, we're back to the point is you need to knock your pride aside. Other than stealing checks, you need to knock your pride aside and get a job. You can get 2 or 3 jobs: McDonald's, Burger King, Whataburger, Sonic, Five Guys. I'm sure all of these places are looking for people to work, but they're not gonna pay you $34 an hour. If it were just you, you can go live off the land, but it's children, and children cannot support themselves. We have child labor laws. So knock your pride aside, pay off your child support, and maybe the AGs will lift the suspension on your license.
Well, there was an agreement, and I did, meet up to the
You-
requirements, and
here's the thing.
they never lifted off my,
Here's the thing.
the license.
You are not working. Your children would not be eating because you're not sending any money for them. So you're gonna get a job while you're on this probation. Do you understand?
Yes, ma'am.
$1,500 fine, probated, proof of employment within 30 days. That's gonna be full-time employment. And for the court, full-time employment, you need to work at least 8 hours a day. So if you need to get 2 part-time jobs to do that, that's what you need to do. There's to be no employment as a home health care provider or with minors. Restitution, if any, to Jack Kelly. Cats 1 and 2. Cats 1 and 2 is to tell you not to take what doesn't belong to you. I really just gave you that course. If it doesn't belong to you, don't take it.
Of course.
But they're gonna give you an extensive course. I don't know what the extensive course is, but it's more than what I've just told you. Not taking what doesn't belong to you is something that you should have learned in elementary school. All right, there's gonna be regular Zoom reporting or in person. And if you report in Zoom to probation inappropriately, your Zoom privileges will be revoked permanently for probation. Do you understand?
Yes, ma'am.
If you're drug tested today, what are the results going to be? What do you mean it should be?
I am clean.
All right, we're going to do a UA today. Thereafter, if he's negative, then it will be random UAs monthly.
Oh, Your Honor,
Yes.
I will be dirty today, to be honest with you.
Well, I mean, whenever people say to be in all honesty or to be honest with you, then what's coming maybe is not honesty. So now you're going to be honest with me. What are you going to be positive for?
Marijuana and meth.
All right, so here's the thing. I understand that sometimes people give you free marijuana, but they don't give you free meth. So again, you're before me, you have children, you're not supporting, you don't have employment. Who knows how they're eating and surviving, but you can have marijuana and meth. So, Ms. Reyes, it's instead of the UA today, We're gonna do regular Zoom reporting in person. We're gonna do the UA hotline, intensive outpatient treatment with probation, field visits 2 times per month, random, 120 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination, parenting classes, and the remaining hours of the community service will be waived if he completes the parenting classes. You must complete parenting classes either way. Do you understand? There should be no unsupervised contact with minors. CPS compliance if applicable. Rebecca, is there anything else that he needs?
Judge, did you announce the TIC numbers and the no contact?
Thank you. TIC night mag number 647566. And what is the number that was indicted, Mr. Froelich?
He said 2021 CR 4509.
That's
That's what he mentioned earlier.
All right, and then taking consideration 2021 CR 4509. Mr. Medellin, we're in the middle of here and I see you. Is there anything else that you need, Mr. Medellin, from this court in order to be successful? Sorry?
Is there a way I can get my license?
I'm not in charge of your license. You're in charge of it. If you pay your child support and not be behind and allow your children to eat and depend on you because you brought the children in the world, guess what? When you have children, you can't just have children and leave them at Travis Park and say, go forth and live your life. You're supposed to support them. So if there's a AG's order, you know what that tells me? That tells me that the taxpayers have been paying for your child either through Medicare or Medicaid. And guess what? When that happened, they want to know who the parents are. And then it comes back to you and you haven't been paying your child support. So as soon as you catch up on your child support, then they will probably lift the suspension on your license. So knock your pride aside, go work at Burger King, Whataburger, wherever it may be, and support your children. And that needs to be addressed in civil side. This is criminal side. I'm just dealing with the fact that you forged Mr. Kelly's check, who probably now has to change all of his checks. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, I did, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
That's right.
And you're gonna have to stop using meth, using marijuana, and get a job and support your 2 children.
I
And
am.
be a father that they can look up to.
I am, Your Honor.
All right, make it happen. All right, if you're waiting in the courtroom, probation is gonna go over conditions with you. Mr. Sherman?
Judge, I apologize, my computers went out on me over there, so you had called my name and I couldn't answer.
Yes. Mr. Froelich, you're excused.
Thank you, Your Honor.
You're welcome. All right, have you gone over the motion that you filed? Did you tender that for the state to review? To see if they have any objection? I know.
This
it's a
is an
standard
agreed
order.
order, Judge. That's the standard order.
Well, I know it's standard, but did you talk with the state and they say that they're in agreement to it?
When I litigated that order, yes, we agreed to that.
I know when you say you litigated the order, did you litigate the order with the prosecutors in this courtroom?
Not in the courtroom, but with the district attorney office. This is what they agreed to do.
All right.
Judge, this is Brittany. We spoke about it this morning. We're in agreement to it.
All right, thank you. And Ms. Ferguson, can I have a date on Mr. Lawrence to come back, please? A 30-day reset? All right, see you back on 5/16.
5/15,
5/16.
16. My
Yes.
client need to be here?
Yes,
Okay.
thank you. All right, we're gonna bring the jury in. May 16th.
They're talking to their client.
Judge, on David Perez, we received an offer. It doesn't appear he's on Zoom right now.
Yes, he is here.
The Perez we're seeing, 187th Perez, is Jesus Perez. He's not my David Perez.
All right. Ms. Ferguson, can you see if you can get Jacqueline Nemerson's client here, please?
Judge, I'd like to have his mom involved. He's has an intellectual disability. I'd like to have his mom involved to speak to him about the offer I was able to get from Mr. Groomer. If that would be of assistance rather than trying to get him in right now. I'd like to set something up where his mom can be available.
All right, Ms. Ferguson, can you call Mr. Pettis in 2 weeks, please? And give me a date. All right, we'll come back on April 25th.
Very good. Thank you, Judge. May I be excused?
Yes.
Thank you.
Yes. Oh, thank you. James Mark. Mr. Pettis, I'm going to send you to breakout room number 3 with your clients. All right. At 2:30, we're bringing the jury in.
Yes, Judge.
And Judge, just so I know, after we pick a jury,
All right, thank you. And Deputy Laura, could you unmute me, please? Thank you.
Your Honor, I'm actually just asking for a copy of the stipulations and waivers so I can go over it with my client since the screen share is blocked.
All right, just give me a moment. And the screen share hasn't been blocked. There's just some issue with the screen share.
Oh, well,
I'm gonna send you to a breakout room, Mr. Meyer.
okay. Well, I asked Ms. Ferguson if she could give me a copy of, so I can go over it with the client. That's also, we can be on the same page.
All right, and Mr. Meyer, because we're starting a jury trial, I'm gonna ask that you remain in the breakout room. And Ms. Ferguson will be in the breakout room, but be on mute and not be able to hear any of your conversations with your client, but you can text her when you're done and we'll take up your plea.
Sure, okay.
Oh, that echoes for me. Yes. All right, Ms. Ferguson. All right, so to the clerks and to the prosecutors and Ms. Reyes, I'm going to send you all to a breakout room. We're going to start jury selection, and just so there's no interruptions with the jurors, if you could remain in that breakout room and just move throughout breakout rooms, but not come back to the main room. My understanding is that James Meyer is working on paperwork with Mr. Pettis. So as soon as the paperwork is done with Mr. Pettis, he'll just remain in the breakout room, and when I'm able to take him up, I'll take that up.
Thank you, ma'am.
You're welcome. And Ryan, since you have co-host permissions, you can go to whichever breakout room you choose to go to. You as well, Ms. Reyes. All right, can you all tell me, are you coming, if there's punishment, are you going to the court or to the
Court
judge?
judge.
All right, thank you.
Sorry, Judge, I heard you call me right as I left.
Now, I was going to say, just remain in the breakout rooms instead of the main room.
I understand. Yeah, I did hear that. Me and Brittany will stay in a breakout room so we don't interrupt the court.
All right, thank you. And if your video is off, I've hidden non-participants, so that's fine as well.
Okay.
All right, to both sides then, if you want 30 minutes, what seems to work best is then you will have 15 minutes for general, defense will have 15 minutes for general, and then each of you will have your 15 minutes for specific.
45.
Yes. Sure.
So we're doing 45. Is it 30 minutes for general and then 15 for?
Yes.
Okay.
Push over those.
Are you ready for it?
I mean, I just want to make sure it works.
Okay.
All right, so is this, the charge in this case is it violation of a bond or protective order or assault stalking?
Yeah.
Okay.
Nobody.
Oh, cutesy. Hey.
Deputy. He's not here.
Oh, you're gonna be with Mejia next week, so good luck. Brenda?
I can only do one job. This. My hands are occupied over here.
All right, is your PowerPoint set up?
Yes, sir.
All right, Deputy Laura, you can bring the jurors in. Defense, oh, that's the mother, okay.
Oh, she's gonna get a reset.
Yes, just have her go to the back.
Okay, all right. Sorry about that.
No, she didn't want to leave because she didn't want to get in trouble.
Yeah, never mind. At least she's-
Yeah, I'm
that's
just gonna leave
good.
my
Most of
video
clients
off so it
do.
doesn't show anybody behind me.
Sure. Oh, yes, bring them in.
Okay.
Oh, Michael, who did you bring with you?
Oh, did I not?
No, you didn't.
Judge, it's been a hectic day. This is Ivan St. John.
Hello.
Judge.
Hello.
He knows the case number and case name, so it's pretty good.
Okay, all right, thank you.
Bottom one, way at the end. 1, 2, 3, 4. 7. Great. Second row on top. Second row on top and half the number. 14. 15, bench. Number 15, God has a bench. 22. Oh, we're gonna yes. Yeah. Boy, you're the wrong, what?
That happens.
51. 42.
I forgot to give instructions about that.
No, 44, 44, 44. 45. 61. Just cross it over. Remember? Hold on, let me. Don't sit down, because you're in the wrong spot. 51, next row. Way at the end. 54. Yes. 5. 56. 57. Come on. 57. 58. 9. 60. 61. 62. 64. Oh, I'll get your name. You can put it on the side. Oh, 70. 71, 72.
All right, everyone, please be seated. All right, ladies and gentlemen, welcome to the 187 District Court. I know you all were outside this morning. Through no fault of the state or the defense, I run a second docket as well. So that is why I had you all to leave and to come back at 2, because I didn't want you standing in the hallway so long, although I realized you were there for a while. So happy afternoon. Right? All right, so each of you have some very expensive items in your possession. They are the cards with your numbers on them. So could everyone raise those cards for me, please? All right, I ask everyone to do that because both the defense and the state and myself are going to be asking you some questions. And whenever you want to respond to a question, just raise your card number. All right, so can everyone do that for me? Awesome, you guys are awesome. All right, so this is what is called voir dire. I'm Judge Stephanie Boyd. This is the 187th District Court. You're going to hear me saying the 187th District Court a lot because just what happened happens a lot. And what I mean by just what happens is that sometimes people forget which court number they're in. And so they will come to a different court instead of the court that they're in. And the problem is if one of you goes missing, we have to wait for you. So if one of you go to the end of the hall instead of this courtroom, there's going to be a problem. So what court are we in? Thank you. All right, I've introduced myself and I'm going to have the state. State, if you could introduce yourself, please.
Hi, good afternoon, Michael.
Good afternoon, folks. I'm Mike St. John.
All right, and for the defense, if you could introduce yourself, please.
Hi, everybody. I'm Sergio Ibarra.
And I'm Neil Kalfas.
All right, and if your client could introduce herself, please.
Hi, I'm LILIAN.
All right, everyone, please be seated. Is there anyone here who recognizes any of those parties who have just stood up? If you do, please raise your card. All right, other than just meeting downstairs for the first time, do any of you know each other other than being downstairs? All right, number 33. And number 32. How do you know each other, number 32? Okay, awesome. All right, the other thing, whenever you all are answering, if you're on any row except for in the jury box in this front row, I'm going to need you to stand because the court reporter has to take down everything that's being said. And because of the acoustics in this room, she won't be able to hear you. Our court reporter is Brenna DeMoss. She's excellent at what she does, but I don't want to put too much pressure on her today. So we'll only need one person speaking at a time, but just make sure that you raise your card and answer. It's strange that you two work together. The last time we had an issue where, just one moment. The last time we had an issue where people were on the jury and I asked them if they knew each other, there were two ladies said that they knew each other and we're like, how do you know each other? And they said, I'm the wife, that's the ex-wife. So at least we don't have, well, they got along just well, so at least we don't have that here. All right, I'm just going to go over a few things with you, and then after I go over a few things with you, the parties will go over things with you. So the charge in this case is violation of bond or protective order, assault, stalking. I just want you to think about that for a moment. The United States, people say this is the best jury system in the world. The key to having a great jury system, though, is having jurors who are willing to serve. We cannot have a jury trial without jurors. So the way someone ends up coming to a court and getting to the point where they're having a jury trial is there's an indictment. How many of you all have been stopped? Maybe you picked up a traffic ticket. Anyone here have a traffic ticket before? You guys are so great with the cards. All right, so I've only had one traffic ticket and I was young. So at that point in time, when they did traffic tickets, what they did was, it was actually a ticket, they wrote it now. My understanding now it's electronic. So when you get a traffic ticket and you accept that traffic ticket from the officer, on that ticket, it tells you what you're being charged with and when you have to appear in court. Your accepting of that traffic ticket doesn't mean you're saying you're guilty. Does everyone understand that? And so just having the traffic ticket doesn't mean that it's true or it's not true, you're guilty or not guilty. It's just telling you, this is what you're charged with, and this is when you have to appear in court. Does everyone understand? So when someone is indicted, that indictment is telling them, this is what you're charged with, this is where you need to appear. It is no evidence of guilt whatsoever. Does everyone understand? Cards. See, I'm practicing with cards. Is there anyone who will hold it against Ms. BARRIUS-CONTRERAS just because she has been indicted? Is there anyone here who will hold that against her? Now, there are certain rights that every person who's accused has. Has anybody seen the show, any type of legal shows? Great. You know, the legal shows that I saw were like Mannix, Barnaby Jones, Matlock, thank you, the Paper Chase. So anyway, you will see things where people say that you have a right to remain silent. Has everyone heard that term before? So what that means is that anyone who's accused, the right to remain silent is just not if an officer were to arrest you. The right to remain silent works in a courtroom as well. So that means that anyone who's accused doesn't have to testify against themselves, and it can't be held against them that they didn't testify. Does everyone understand? So a lot of times people will say, well, I wonder what they would have said. I wonder, you know, if they would have said this or if they would have said that. It's okay to wonder, because sometimes you can't put things out of your mind. But what you must not do is consider it and weigh it against the person or hold it against them. Does everyone understand? So if Ms. BARRIUS-CONTRERAS decides not to testify, is there anyone here who's going to hold that against her? All right, thank you. Now, the other thing I want to talk to you about is burden of proof. Now, the burden of proof is proof beyond a reasonable doubt. How many people have heard of proof beyond a reasonable doubt? All right. When I was in law school, we had to memorize the definition of proof beyond a reasonable doubt. And you're so excited when you're able to memorize that. So I knew it forwards and backwards. I had my first trial as a defense attorney. And guess what? After that first trial, the rules changed. There's no definition for proof beyond a reasonable doubt. So there's no definition for it. What people usually do, and I've done it as a defense attorney and done it as a prosecutor, is they tell you what it's not. So you're in a criminal court. There are different burdens on the civil side. One burden on the civil side is called clear and convincing evidence. Clear and convincing evidence is the burden that's used to make a decision on whether or not someone's parental rights should be terminated. Does everyone understand? All right, people consider that the high burden, but the highest burden is proof beyond a reasonable doubt. I cannot give you a definition of it. The state and the defense could not give you a definition because there is not one. Does everyone understand? Now, one of the other rights that people have when they are accused is they are presumed to be innocent. And what that means is until and unless the state brings you evidence for each and every element of an offense and prove that to you beyond a reasonable doubt, anyone who's accused is presumed innocent. Does everyone understand? The burden to prove a case rests with the state. It never shifts to the defense. Does everyone understand? Now, in Texas, there are 2 phases to every criminal trial. The first phase, people consider it guilty phase, but really it's guilty, not guilty phase. So evidence is presented. And when that evidence is presented, you can make a decision if someone's guilty or not guilty. Now, in Texas, there's a second phase. If you determine that someone is guilty, then the second phase is what's called the punishment phase. Now, when someone is charged with a criminal offense, they have to make a decision. They have to make a decision whether they would go to the jury for punishment or to the court for punishment. Now, their selecting of that has nothing to do with whether they are guilty. Does everyone understand? It's the law that they must decide if they were found guilty, whether they will go to the jury for punishment or the court for punishment. In this case, the decision has been made that if she were found guilty, she would come to the court for punishment. Is there anyone here who is going to hold it against her for exercising her right to come to the court for punishment if she were found guilty? Now, people are going to talk to you about what's called a one witness rule. This is what a one witness rule is. And these are all hypotheticals. So assume that the state were to call one witness. They're sworn in, they're sworn to tell the truth. They testify. You believe their testimony. And their testimony proves every element that the state needs to prove. And their testimony proves that beyond a reasonable doubt. Is everyone following my example so far? All right, the question then is usually asked, sorry, do you need something? Okay, the question then is usually asked, will you be able to find someone guilty if the state were to present one witness? You believe that witness, and that witness proves every element. Is there anyone here who would not be able to find someone guilty based upon that? And I'm using a hypothetical. It's not about this person who's charged here. It's not about Ms. BARRIUS-CONTRERAS. So is there anyone who would have issues with that? All right, juror number 51. All right. And everyone, I'm so sorry about the heat in here. We have no control over the thermostats. I know people see the thermostat there and you're probably like, why doesn't the judge turn on the AC? I have absolutely no control over that. So we've been sweating profusely here. Now, here's the other question. Is there anyone here whose English is not your first language? All right, I'm gonna need you to raise your card. So number 29, 37, 49, and 54. This is the reason why I asked that question, because in order to be on the jury, you have to be able to understand what everyone's saying, and the language that's going to be used is English. So of the persons who raised their hand, number 29, 37, 49, and 54, have any of you had any difficulty understanding the English language?
No.
All right, 29, thank you. Well, 29, are you saying you don't understand?
I understand everything. I moved from Puerto Rico in 1979, and I hold a federal job for many years. No, I understand.
All right, thank you. I always have to ask that question. I enjoy that people speak other language. I think it's beautiful. I wish I spoke 6 or 7. I only speak French. So I asked that, and the reason why I asked that is because sometimes we will have people on the jury panel and they will say, I don't speak English, I don't understand what's going on. And it has been many different languages. So I just want to make sure of that. The last question I have for you before I turn it over to the state, is there anyone who has any type of time constraints? And when I say time constraints, I mean, you got a flight planned this week and you know, it's non-refundable and you're not taking me. Is there anyone else? All right. Number one, when are you leaving?
No, I'm not leaving. My daughter, I don't have anybody to pick her up. She can only stay to school till 5.
Oh, all right, that's not gonna be a problem. Number, are you 9?
Yes.
Yes, what is your time constraint?
It's not Thursday. I have to go to a dentist.
All right, number 4.
My friend's not till next Tuesday, so.
All right, thank you. 22,
I'm supposed to speak at a religious festival next week, next Thursday.
Oh.
So not day after tomorrow.
all right, thank you. Wait, next Thursday?
Today is Tuesday, so not day after tomorrow, sorry, not day after tomorrow, but a week from this Thursday.
Oh, so it's not this week.
Correct.
All right, thank you. Number 34,
Wednesday afternoon,
what are you doing? And I need everyone to stand if you're past that row.
I gotta go to work. I work in New Mexico.
All right. What are you doing in New Mexico?
Oil
All right, thank you. 37,
Friday, going to the valley to my mother.
all right, thank you. 14,
I have a funeral tomorrow.
oh, I'm sorry to hear that. Thank you. 24,
I have a 29.
all right, thank you. 46,
Daughter's district attorney, small.
Repeat the last part.
My daughter's district attorney, small.
District.
well, is she gonna win?
Hope she advances to the
All right, awesome. And what time is that?
9:30.
All right, thank you. 17,
Moving to Houston on the 30th.
all right, thank you. Number 51,
I don't know if you're gonna ask or not, but I have a medical situation.
all right, thank you. Number 29,
I'm traveling on April the 30th. If they don't have an extension or the trial there, it can be there.
I'm sorry, you're,
April the 30th.
30th.
all right, thank you. Number 70,
I have an appointment tomorrow for a wedding dress fitting.
is a wedding dress for you?
It's true. My wedding is on the 30th.
Does that really need to be taken care of?
I have to pick, it can be rescheduled. I've had this for months. The ladies will book that.
All right, thank you. You should have been on what is that show? Pick the Dress or something? Say yes to the dress. All right, 75.
Friday afternoon, we're leaving for Corpus.
All right, are you driving?
Yes.
All right, what are you doing in Corpus?
Family vacation.
Do you really want to spend time with your family? Okay. All right, everyone, I'm going to turn it over to the state. Sorry, number 2.
I have a doctor's appointment for my knee. I tore something in there. I need to go see a specialist.
Oh, wow. Do you know what you tore?
No, I forget what it's called, but that's about clear.
Meniscus?
Yeah, that's what it is.
Oh, wow. Okay. All right, so everyone, when I turn it over to the state of the defense, I want you to remember something. The examples that they give you are not about this case. They're not allowed to talk about the facts of this case or what they assume are the facts of this case. So when they speak to you, they're speaking to you in hypotheticals. Does everyone understand? All right, state.
Hey, Gar, can you let me know when I've used 25 minutes?
Yes.
Thank you. Good afternoon, everyone. Thank you again for coming. I'm like the judge, I can't sit still a lot, so I'll probably be walking around, so please forgive me. And Brenda loves when I walk around and definitely have my back to her, so. So again, my name is Michael Lowell, I represent the state of Texas in this case. So who got their juror card in the mail and they're like, felt like this? 49? Hey, there are some people who like actually going to jury duty, but most people, understandably, you have your own lives going on. So we just, everybody here, but it's been the same. We want to thank you for being here because we can try these cases without jurors. So the judge talked earlier about what this process is about. And this process is finding 12 fair and impartial jurors that can sit, listen to the evidence, and make a determination on the evidence. So what is fair and impartial? Who knows who this person is on the screen? See a lot of cards. I'm just gonna pick people. Juror number 19. Here. Willie Nelson, right? What does Willie Nelson love? It's in the picture. Weed, right? Marijuana. So there's no like question about this. I think he's even alleged to smoke pot on top of the White House. Is Willie Nelson necessarily going to be the most fair and impartial juror on possession of marijuana case? No, right? Because he disagrees with our marijuana laws openly and frequently, it appears. But does that mean that Willie Nelson necessarily going to be a bad juror on a murder case or on an assault case? No, right? So what we're trying to find out is whether you can follow the law. There's a lot of people saying, well, I might not agree with the law, but I can follow it. That's still okay. What we have to find out here is, do you understand the law? Can you follow the law? And then can you apply the facts of the case to the law that the judge is going to do? Okay. Everybody understand that concept. I like to think about it this way. It's kind of like an equation. Fair and partial juror equals somebody that can follow the law that the judge gives you and will base your decision only on the facts. Okay, I know some people are more visual, and so that's kind of how I like to put it. I'm a little bit more analytical. Everybody understand that? Does anybody not understand that? Next one, Judge mentioned earlier, they or the defense, we can't give you a definition of beyond a reasonable doubt. But what we're able to do is kind of give you an idea of what beyond a reasonable doubt is not. So beyond a reasonable doubt is not beyond all doubt. If you knew something 100% beyond a shadow of a doubt, what would that make you in this case? Anybody? Number 14? Next, maybe? About a witness, right? Because you were there, you saw what happened, right? I don't think any of you, I didn't see any of you in any reports or any on these cases. And so you're not a witness on this case. You're not going to know exactly beyond a shadow of doubt what happened because you weren't there. It's not 100%. And possible doesn't always mean reasonable, right? We live in a world where everything seems to be possible, right? Especially these past 2 years. Is it possible that an alien species we didn't know about invaded the defendant's body and then forced them to commit this crime? Possible, maybe, but I can't say it's impossible, but does that mean it's reasonable? That makes sense to everybody? And reasonable doubt, it applies to the elements of the offense. And we're going to go over the elements of the offense later. So if you have a reasonable doubt as to one of the elements of the offense, then the state hasn't met its burden of proof. But if you do not have a reasonable doubt as to whether the state met each and every element beyond a reasonable doubt, then the verdict in that case would be guilty. Okay. So I try to illustrate it this way. I need some pictures during this. Who here has dogs? Who here just has one dog? Okay. Who here has come home to a situation like this? See a bunch of cards, right? Who raise your cards again in that last question? Juror number 7. Let me find it a little bit. So when you came home, you saw something similar to this, and what happened? And do you know who got into the trash? Okay. You weren't there to see it though, right? But the dog, the only one in there that could have done it, right? Yeah. I mean, I've gotten juror responses like, well, maybe somebody went through the doggy door and rifled through the trash and threw it on the ground. I think that goes back to that first part I talked about. Possible, not necessarily reasonable. Unless you have some trash being living in your neighborhood that just collects trash. Does that make sense to everybody? Does anybody have a question on beyond a reasonable doubt? So these are the elements that the state has to prove to you beyond a reasonable doubt that on or about a certain date in Bexar County, Texas, the defendant violated a condition of bombs that in a family violence case concerning the safety of the victim by committing family violence, by intentionally or knowingly committing assault. These are a lot of elements that break it down to you pretty easily. There was a bond condition in place and the defendant violated it by assault, potentially knowing assault. Pretty, there's a lot of words in there, but conceptually, I think it's pretty easy for people to understand. Does anybody have any questions, just generally or initially? So I'm gonna skip through these slides. I want to talk about obviously what the elements of the offense we had to prove that it was a bond condition within a family violence case that relates to safety of the victim. So obviously, based on the elements of the offense, this case is going to involve family violence. So family violence in the state of Texas also includes dating violence. It is defined by an act of a member or family or household against another member of the family or household. It includes dating violence. Dating violence is that same type of act committed by a person in a dating relationship or an ex-dating relationship. So it's pretty broad in the state of Texas. As far as family violence cases, why is it important to prosecute family violence cases? Why do you think it's important to the state to prosecute family violence cases?
I can't hear you.
Sorry? Protect the innocent. Anybody else? Number 18. To prevent it reoccurring. We hear about this sometimes. Finland believes a lot lately and prevent that cycle of violence. Anybody else? This is like sequel, by the way. So once you are in the front, you're in the splash now. And this pandemic's been hard on me, so I might be looking like Shamu right now. Right, so a lot of these deal with the relationship between the defendant and the victim. And so they might not be in a situation where they might be able to come forward or they feel like they can come forward. Because who are the victims in family violence cases? Anyway, this is an easy question. 18?
It could be anybody.
Right?
Child, wife.
It's a family member or somebody that they're dating or somebody that they used to date. Does that make sense to everybody? So victims on family violence cases, they kind of come in all shapes and sizes, right? Because if you're like me, you're like my family member. We kind of have this continuing scale. We don't always have, our cousins, our aunts. They're not all Audrey Hepburns, right? Sometimes they come with baggage. And so I just want you to take that into mind. We'll talk about that in a little bit. Where does family violence usually occur? Juror number 53. Can you stand up for me? 53, can you stand up for me?
At home.
At home, right? Within the home. That's generally where these things occur, right? So who's usually around?
Nobody.
Number 42, nobody, right? Who might be around? 22.
Other family members.
Right, there's potentially other family members. So how many actually witnesses, and I mean people in the home, are able to testify in many of these cases? Just think about it. If it happens in the home and nobody else is in the home, they're number 17. 15? I think that's wrong all the time. It's okay. It's been a long day, I'm sure.
Sorry, question.
Sorry, I didn't do that to you. If family violence occurs in the home, how many witnesses are able to testify? And remember, the defendant doesn't have, they have a right not to testify.
Who would be the one one witness, probably the one that's perfect.
Right? Might be the victim in the case, right? They might number she had. Number 42.
It's a he said, she said situation.
Many times it is, right? Because that's going to be the only people there.
A lot of times when an officer goes into a domestic situation like that, the victim will turn on the officer.
Right? We do see that in some cases. All right. Knowing that it is sometimes like juror number 42 said, just say he said, she said, where we only have potentially one witness who's actually there. Is that a problem for anybody? Okay, if it is. This is a safe place. Juror number 70, did you raise your card?
Conflicted about it. Like, I feel like it's a problem.
Okay, thank you. Juror number 51. Anybody else? Juror 47.
For the case like that, we have a person who says it is and says it isn't, and that's all that they have to go on. That puts you in a very hard spot. It's, which one do you like?
Okay, thank you. Juror number 59. You want to expand on that? Or? Thank you. Anybody else? Did I miss? And so this is kind of what we talk about. It's a cycle of violence. This is from the University of Minnesota, which does this model or kind of the ethics on this. It's the cycle of violence that we talk about sometimes. Not that be sometimes where people don't want to cooperate, right? It's honeymoon phases, and things like that. I'm gonna just let me say something. Sorry. Turn off your sheet.
It only gets worse. It never gets any better. It only gets worse.
Thank you. I'm gonna just because I want to make sure we get out of here before 5. I'm gonna move on past this. So to kind of further illustrate this issue, in this hypothetical, you have to get robbed. I'm sorry, it's just what it is. Because I've had jurors that, well, I choose not to be robbed. That's not part of it. So if you had to be robbed, where would you rather be robbed? The picture on the right, or rather, your left, my right, or the picture on the right? Right. Why is that? Or witnesses, right? I mean, I went to A&M. I don't want to go there anyways. I don't want to say it, but anyways. Yeah, right. There might. You'd rather be in a place where there's what? How many? 100,000 witnesses versus in a place where there's no witnesses. But who chooses where a crime happens in this type of cases? I'm hearing the perpetrator, right? The person who's committed the crime. They get to choose when it happens, where it happens, who it happens to, how it happens, who's around, right? And so we don't always get, we would love to have all of our cases be those 100,000 witnesses, but that just isn't the reality of these types of cases. Does that make sense to everybody? Okay. I'm probably beating a dead horse on this, but this is really important in these types of cases. So let's say this is a hypothetical. You are, unfortunately, you are not selected to enter. You are heartbroken walking back to your car. You're just kind of in a fog, dazed because you're so upset. You're not really walking your surroundings. You get to the empty parking lot or garage. And this is Bear County, so none of the cameras in the garage are going to work. And nobody else in the garage with you, and you get robbed or mugged. Should that case get dismissed? Just because nobody else is there, there's no cameras. Yeah, right? So we gotta have understand the situation for yourself, right? In these family violence cases, we're not gonna have necessarily camera footage. We're not necessarily gonna have a ton of witnesses. That's just unfortunately the reality of this case. So this is a scaled question. What I'm gonna do is I'm gonna read it to you, read the responses to you, and then I'm gonna call out if you agree with number 1 to raise your cards. If you agree with number 2 to raise your cards and so forth. So the question here is if only one person testifies, that is not enough to find someone guilty. Number 1 is strongly disagree. 1 witness is enough, it's believable. 2 is disagree. I will decide based on the testimony. 3 is agree, I want more. And 4 is strongly agree, I need more. So the distinction between 3 and 4 is want and need. Again, the question is, and if only one person testifies, that is not enough to find someone guilty. Again, there are no wrong answers to this. Who falls into to number 1? Strongly disagree. 1 witness is enough if believable. See juror number 5, 11. I don't think 16, 63. Okay. Who falls into number 2? Disagree. I'll decide based on the testimony. There's a lot of y'all. I'm sorry, Brenna. I'm sorry. 1, 2, 3, 4, 6, 8, 9, 10, 12, 13, 14, 15, 17, 18, 19. You put your cards down as I call you. 22, 23, 24, 26, 27, 29, 30, 31, 32, 33, 34, 35, is it 29? You did. You did. 36, 37, 38, 39, 40, 42, 43, 44, 45, 46, 48, 49, 50, 52, 54, 57, 58, 59, 60, 61, 62, 65, 68, 72, 73, 74, 75. I'm sorry. I'm so sorry. Who falls in category number 3? I agree. I want more. Okay. I have 7, 20, 21, 25, 41, 47, 51, 53, 55, 64, and 67. And then who falls into category number 4, strongly agree, I need one. I see number 28, 70, and 71. Did I miss anybody? Not call anybody's number. Surprisingly, I don't remember which ones I got. And this is going back to what the judge said. She explained the one witness rule. I just want to break it down a little bit more. If you heard from just one witness who you believe beyond a reasonable doubt, and in this you believe his or her testimony beyond a reasonable doubt, and it proved to you each and every element beyond a reasonable doubt. This is not saying I can't find someone beyond a reasonable doubt with just one witness, but the assumption or the hypothetical makes you include and say, well, in this, I'm going to believe this one witness, I'm going to believe them beyond a reasonable doubt, and I'm going to believe that they proved each and every element beyond a reasonable doubt. So again, that question, who falls in category number 1? I would still require additional evidence to find the defendant guilty. Okay. A lot of cards, so I'm going to re-explain it because I probably didn't do a great job. We're just coming out of this pandemic, I'm a little rusty. So in this hypothetical, if you believe this one witness, you believe them beyond a reasonable doubt, and you believe that they proved to you each and every element beyond a reasonable doubt. Normally, that verdict would be guilty. But there's some people say, well, even if I believed all of the elements were met beyond a reasonable doubt, I would still require the state to bring additional evidence. Does that make sense, everybody? Okay. Who falls into category number 1? I would still require additional evidence to find the defendant guilty. I see 6, not 3, you got 3, 6, 9, 17, 21, 28, 29, 44, 47, 51, 53, 54, 64, 67, 70, 71, and 72. All right, thank you guys. So obviously, you're going to be hearing from a witness or witnesses on this case. And so at the end of the case, the judge will tell you that you are the exclusive jury to find whether the belief or credibility of the victim, to determine the credibility of the victim and the weight to be given their testimony. I'm actually quoting that one. So you are going to determine the credibility of each and every witness. We do this kind of intuitively every day, whether you're probably judging my credibility right now, understandably, this guy telling the truth, not. We do this every day with cashiers, coworkers, or children, right? So what are some things that you would look at in order to determine or gauge the credibility of witnesses? Number 15? I'm sorry? Their age, okay. Juror number 18? Their mental state. Juror number 19? Body language. Body language, okay. Juror number 42?
If they can look you in the eye and answer your questions.
Okay. Eye contact. Juror number 53.
I can't hear you or see you.
All right, so everyone, if you are not in the jury box or on this row, gonna need you to stand.
I was also body language.
Thank you. And I'm sorry, Jeff, I should be reminded. I'm sorry. So a lot of we talked about this, and these are some of the answers that I've gotten previously in these jury selections, right? Their demeanor, how are they acting while they're testifying, right? You might look at is their motive. Do they have a dog in the fight to say something one way or another? Is there some history behind it where they might want to say something a certain way, or see they said they saw something, or say they didn't see something, right? Is there a motive behind their testimony? What they say, I think it's when I always read that, I'm like, what did I mean by that? Just that, does what they're saying even make sense, right? Is it just on its face? Does it sound right? Is it consistent? Is it consistent with maybe previous statements, or is it consistent with the other evidence, or is it consistent with the other witnesses? But I want to just talk about consistency a little bit. That could change between witnesses, and that's kind of understandable. And when I like to, we're just ending the episode, right? I think it's a participating. I'm just so sad. So just coming off the stuff. So let's say you did go to one of the parades to see which is a pile of flowers, and you went with a friend. Do you think you would be able to list, even 15 minutes, the floats that you saw and in the order that you saw them? Yeah, right? You might be able to. I think I had a Aggie back there. I'm gonna know if the A&M dance there, right? I always remember that. I'll probably remember the long one, but I might remember some of it. It was kind of a pile of it, but I might remember every float, every shoe that they're wearing. And do you think my memory would be different than the friend that I went with, right? Maybe they're the Longhorn, I'm the Aggie, and I remember one part, they remember the different, right? Does that mean that y'all both weren't at the same parade? Right? So sometimes when we're looking at things, we have to look about is kind of a big step there. Just an inconsistency doesn't mean necessarily either one person's lying, right? So even let's say I went to the parade last week. Do you think my recollection of the parade is going to be the same a day after versus a week after? Or a year after? Right? Does that mean that I'm lying that I said that I went there? Does it mean that I'm lying that I actually stayed the whole parade?
All right, 25 minutes.
Thank you, Judge. Yeah. So talk about briefly evidence in this case. Would you repeat after me? Testimony is evidence. Testimony is evidence. The judge is going to tell you that. I'm going to remind you during closing. That's the largest part of most of our cases, right? It's not going to be police reports and physical evidence. A lot of it's just going to be people telling you what happened, what they saw, what they encountered while they're there. So testimony is evidence, and you have to judge again that testimony based on judging the credibility of them and determining whether they're credible and whether you should be giving weight to their testimony. That makes sense to everybody? What type or kind of evidence would you expect in these types of cases? Juror number 23.
Verbal,
I'm sorry?
verbal,
Verbal, like testimony. Juror number 70.
Physical,
Physical, what do you mean by physical?
or pictures, or if there's actual violence.
Right, so you might get pictures or something like that. Anybody else? Number 42.
But will you get blood type and physical, or forensic evidence or anything like that?
Well, I can't tell you, right? But if, you know, again, it's possible. Is that something that you would expect in these types of cases? Okay. Juror number 67.
Correspondence, like text messages or letters or emails, stuff like that.
Okay. Oh, number 4.
I was gonna expand on physical and like the forensics, if there's like marks or something, physical, but evidence that shows.
Okay. So some type of injury or photos or something. So again, you mentioned some of these things. Is there anybody here that would need a particular piece of evidence or could find somebody guilty of this? Number 16, what would that be? Okay. Leah? I'm going to pass through this. Self-defense, this is what our law provides. A person is justified in using force against another when, to the degree the actor reasonably believes the force is immediately necessary to protect against the actors, again, protect the actor against the other's use or attempted use of unlawful force. That's our definition. I can break it down to you pretty easy, I think. Comes down to 3 things. Is it reasonable? Is it proportional? And is it necessary? Kind of going back to that. To the degree. That means, is it proportional? Is it immediately necessary? So again, necessary. And then reasonable. Again, has to be reasonably believed the force is immediately necessary. Yes. Yes, I can finish up right now. I'll go through my final questions later. And with that, Judge, I'm not giving you back any time, but thank you.
All right, thank you. All right, everyone, we're going to give you a 10-minute break. And so if everyone can be here, back here, I'll give you 15 minutes. Everyone can be back here by 3:45. So before you run out the door, look to your left, look to your right, the way they asked you to do that in paper chase. Remember who's next to you, because we cannot start unless everyone is here at the same time. So 187 District Court, 4th floor, all right? All right, everyone, please rise. And everyone, please leave your cards in the chair. Yes, please.
If you're a jerk, please step
You're looking
down.
round again, sorry.
We need to take a break. Thank you.
I got my coach. I got my 12 way. I'm done. Yeah.
Oh, you can wait.
Oh, wait, he's from Bowie, so we had a reception. It's a 2.5-hour plane ride on Southwest. It's not luxurious. That's true.
Congratulations.
All right, Mr. Pettis. We're gonna take up your matter. I don't know what's taking Mr. James Myatt. Can you show your video, please?
Yes, I'm right here. You don't see me? All right. There you go.
All right, Mr. Myatt, if you can unmute. Are you able to take a plea? I know, you're doing great work. All right, the court is calling 2022 CR 3531W, State of Texas versus Jesus Perez. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
James Marat, attorney for defendant,
All right,
Jesse
Mr.
Marat.
Myatt, for some reason, we're not able to hear you.
I think it's our system, Judge.
Just a moment.
Okay.
Go ahead. No?
All right, we're not able to hear you, Mr. Myatt.
Sure about that? I'm here.
So do y'all have your audios on?
Judge, I don't know. Can you hear me? I can hear Mr. Mayrat.
Yeah, I can hear him as well, Judge.
Yeah.
Okay, now we can hear. All right, could parties announce for the record for the state?
Michael Villarreal for the state.
Oh, Brittany's here. All right, Brittany Sparks for the state for the defense.
James Marat for defendant.
And are you Mr. Pettis?
Yes, ma'am.
You're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No objection.
No objection.
Mr. Pettis, I'm showing you what's entitled defendant's consent to appear by video conference. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am. Yes, I did.
All right, I need you all to speak up. The court will find that the defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled application for community supervision or just community supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am. Yes, I did.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor, and I have reviewed it with the client.
We'll find that the state is in compliance with discovery. Mr. Pettis, I'm going to show you what's entitled waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am. Yes, I did.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, ma'am. Yes, I did.
Did you also understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, ma'am. Yes, I did.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, ma'am. Yes, I do.
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes, yes, I do.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you what's entitled information. Did you review that document with your attorney? Did you understand it?
Yes, ma'am. Yes, I did.
Counsel, do you waive the reading of the information?
Yes.
Yes.
State, are you proceeding on the information as presented?
Yes, Judge.
Mr. Pettis, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, yes, I did go over.
You understand your charge of possession of controlled substance, penalty group 1 gram to 4 grams, that's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, yes, I do.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I do.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call on the right to remain silent?
Yes, I do.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, I do understand.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, I do.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do, Your Honor.
Mr. Pettis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, they haven't.
Are you satisfied with the way you've been represented?
Yes, I am.
Are you a U.S. citizen?
Yes, I am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial, showing the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, I did.
According to the plea bargain agreement, punishment is to be assessed at 6 years in the prison. There's a $1,000 fine. There's no application for deferred adjudication. State recommends community supervision. State will take in consideration 2020 CR 8235. There's restitution to Andre, Andre Clark, and cause number 2020 CR 8235, $60 restitution to the Bexar County Criminal Investigation Laboratory. Did you understand that to be the plea bargain agreement?
Yes, I do.
Defense is at the plea bargain agreement.
Yes, it is.
State is at the plea bargain agreement.
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, I did and do.
Do you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I do.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 6 years. There'll be a TAP evaluation, 200 hours of community service restitution, no contact with Andre Clark, the MRT course, and felony drug court referral. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, I do.
Then to the offenses charged in the information, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea?
Yes, Judge. State offer states Exhibit 1 and all attachments.
Any objections?
Objection.
Mr. Pettis, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I did and did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, sir. Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, I do.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes.
All right, if reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
No objection. We sure can.
Anything you wish to say on behalf of your client?
Yeah, Mr. Perez is trying very well, very hard. He has completed a probation before, albeit unsatisfactorily. He comes back to the court again. Certainly, he realizes he's struggling with addiction issues, and he certainly would benefit from a court order to participate in a rehabilitation program. I think he wants to get back to work and show the court that he can comply with conditions of this probation.
All right, Mr. Pettis, do you have any children?
Yes.
What are their ages?
15. They live with their mother. I have got my rights stripped away. They don't live with me.
So your rights have been terminated?
Yes.
All right, this is what the court is going to do. The court is sentencing you to 6 years in the prison, suspended and probated for 6 years, $1,000 fine probated, taking consideration 2020 CR 8235, restitution to Andre Clark in 2020 CR 8235, $60 restitution to Bear County for laboratory testing, 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. Referral to felony drug court. That's to be done while in custody. The MRT course. Proof of employment within 15 days of release. No employment as a home health care provider or with minors. No unsupervised contact with minors. Parenting classes. Regular reporting by Zoom or in person. So if you can't report in person, I'm sorry, if you can't report by Zoom, you'll have to report in person.
Yes, ma'am.
Field visits 2 times per month, random.
Yes, ma'am.
UA hotline upon release.
Yes, ma'am.
How often were you using drugs, Mr. Pettis?
Recreationally, not gonna lie.
No, it's not recreation if you have this amount of drugs. So how often were you using drugs?
Regularly, daily basis.
All right. So if felony drug court does not accept them, and they should accept you if you're honest. If you're dishonest the way you were with me, they're not going to accept you. You understand?
Yes, ma'am.
So if he's not accepted into felony drug court, I'm going to want him an ISF cognitive and substantive. And if he does the cognitive and substantive, then he doesn't have to do the MRT. Rebecca, is there anything else he needs?
Judge, the no contact order.
All right, there's to be no contact with Andre Clark. Mr. Pettis, is there anything else you need from the court in order to be successful?
No, ma'am. Everything's perfectly fine.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am. Yes, I did. And do.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, yes, I do.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, yes, I do.
If you have a question over what weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, yes, I do.
All right, we're off the record. Mr. Pettis, good luck to you. I'm going to send you to a breakout room. Probation will go over conditions, and Rebecca, if you can make sure he's released from the breakout room.
Yes, ma'am.
I'm going to open all the rooms now. And if you go back to that breakout room and Ms. Reyes, he is going to breakout room number 3.
Okay, thank you, Judge.
You're welcome.
Are we waiting on any more, please, Judge?
No, we're done.
Okay, thank you.
Thank you. of time people who are coming through these side doors to speak with me and giving me papers. That is not anything related to this case. As I said, I still have cases that are going on even while we're doing jury selection. And I see for the defense, another attorney has joined. Could you introduce yourself, please?
Hi, my name is Jonathan Chavez.
All right, does anyone know Mr. Jonathan Chavez? And what is your number, sir?
67, sorry.
67, no problem. All right, defense, I'm going to turn it over to you.
Thank you. All right, good afternoon, everybody. First and foremost, I want to say probably the most important thing, which is Juror 23, thank you for being the hero, because it really is hot in here. I'm sorry, guys. I'm going to try to go through it quickly so we can at least talk about these things that are very important regarding what the judge has already touched on, states touched on, in order to be a juror in this type of case, okay? First and foremost, I want to introduce, I want to do a little bit of a more thorough introduction as to who's sitting at this table. My name is Sergio Ibarra, and with Neil Kalpas, we both are attorneys with the Kalpas Law Group here in San Antonio, Texas, and we both proudly represent LILIAN Barrios. Now, just to make that, since I made that a little bit more clear, does anybody here know any of us or anyone else in this court? Raise your card. Okay. Now, a little bit about myself, first of all. I was a prosecutor with the district attorney's office some time ago for about 5 years. I was under Susan Reed. Okay. I actually really love my job. I enjoy doing it day in, day out. Tried a lot of cases when I was in misdemeanor land, doing misdemeanor work, and then I got promoted to do felony work. Did a lot of DWI, like very serious DWI cases. Did some family violence work. Okay, so I did some prosecuting on the family violence side. The only reason I left was because my wife, who happened to be in the Air Force, she's retired now. She got stationed in North Carolina. So I ended up leaving with her, going over there and working on the base a little bit in Goldsboro, North Carolina. Okay, enjoyed. So I had a lot of friends there. When I came time that Crystal, my wife, ended up being restationed back at Lackland to become a drill instructor. And so I really didn't think we were going to come back to San Antonio, and one of the defense attorneys who I had a lot of problems with ended up becoming my boss. Okay, so but we respected each other. We all, we knew what each other brought to the table, and it's turned out to go pretty well. Okay, I've been doing that ever since. Now, together we represent, as I mentioned, Liliana. Liliana has lived here pretty much her entire life. She's 28 years old. She moved here when she was 8. And has lived here almost all of that time, except for a couple of years when she moved to Illinois, to Chicago, to do some work over there. And what that work was, she was actually a character or a person on a reality television show. Okay. And I think that the name of the television show is Black Ink. Anyone ever heard of that show? Raise your card. Okay. Now, just like the show indicates, Liliana does some tattoo work. That's one of her archer skills. She does other things though for a living, and so that's something that she had been involved with. Now, I don't know. Having said that, does anybody know who Liliana is based on the television show? Raise your card. Now I'm going to ask you guys, this is a very important question, I believe, is because of the fact that she was on a television show or had dealt with any of those things, would anyone hold that against her? Raise your card. Okay. Does anybody have a problem with criminal defense attorneys? I have to ask that question because I found that some people feel that way. Raise your card. The main reason why I wanted to introduce myself, wanted to introduce Neil and talk about what we have done is because I want to impress upon you guys, and it's very important. We love this system. We love the legal system. I think it's important. I personally believe that it does not work unless everybody on either side is doing their jobs to the utmost ability, so that the prosecutor can end up working with the defense attorney out of mutual respect. Okay. And that's to tell you guys that we're not the people that would be here to defend the offense. of violating a protective order or defend the offense of an assault with family violence allegations, okay? We're here because, and we'll talk about the presumption of innocence, but we're here to discuss, and because Lilian is not guilty of this offense, okay? And it's to play out this entire system, okay? Anyone have a problem with that? Okay. This is my favorite part of trial, as you can probably surmise just by me walking around and talking to everybody. And it's because it allows us an opportunity to have an informal conversation with everybody here, okay? And what I mean by that is I want you guys to be talking with me to the degree that you're comfortable so that you can give the most honest answers that you possibly can. Feel comfortable doing that because there are no wrong answers, okay? In this section, this jury selection or dire, whatever they call it, there are no wrong answers as long as the answers are honest, okay? Nobody here is going to judge you for any of your opinions, any of the ways that you feel about the law and how it's set up, how you feel about law enforcement, how you feel about the system, okay? Because the words that we're taught in law school they're kind of loaded words. Bias, prejudice. These are words that have been around, for a long time and recently have been kind of come to the fore in our culture, right? But here's the thing. Here's what it really means. It means your opinions, how you feel about something in here and in here, okay? Because that matters. The reason why we pull, one of the reasons why we pull people from the community to come in here and sit as jurors is because you get to live everyday life. You bring all of your experiences, all your sensibilities, all the things that you learn as personal lessons, and that's what we need in this place. Okay, not an egghead like me who does this day in day out, enjoys writing briefs and all of those things. No, it's got to be people who have those experiences, aren't in here day in day out, who can look at evidence, look at the facts, and apply that to the law, and be able to scrutinize it as though perhaps it was them that would have to face charges, right? We want people to care, in a nutshell. Does anybody have a problem with that or a question? Raise your card. Okay, thank you. One of the most important, I guess, examples that I can give about this type of thing is, again, about my wife, and it comes down to something called sushi. Everybody knows what sushi is, I hope, right? Now, my wife, and we were talking about where to go to dinner on a Friday night. If I say I would like to have some sushi, my wife will say, no, I don't want to do that. Almost every single time. And that's all well and good. Now ask her why. Why don't you like sushi? She says, because it's gross, I don't like it. I don't like the taste, I don't like any of those things. And then if you ask her, if you really scrutinize it, and you ask her, she'll tell you she's never actually taken a bite. Okay? But that's her feelings, right? I might feel a certain way about that. I might say, well, that's unreasonable, that's this or whatever. But really, truly, she's entitled to that. She has the right to do that. And again, that's to impress upon you guys that y'all have the right to say and feel whatever you feel about the law, about the facts, about the system. Okay? All right. Who here, please raise your card, has ever been accused, no matter what it is, the smallest thing to the biggest thing, has ever been accused of something they didn't do? Raise your card. That's about right, right? Thank you. And I'm gonna pick on somebody in this slash zone as it's mentioned. And since juror 23 is 0, I'm gonna ask you, sir, how did it make you feel to be accused of something you didn't do? What's that? And was it frustrating?
And a lot of things that normally you don't feel.
Right.
Especially when trying to explain it, they don't really say.
Thank you for that. Now, that calls to mind a scenario that happened in my life, okay? And talk just a little bit about this. When I was a kid, freshman in high school, sophomore in high school, I took a rhetoric class, kind of like an English class, and I was a big reader. Loved writing, tried to like, work all those things out. For whatever reason, it was a big deal to me to do that. And I just enjoyed it, and I still do, right? And so I ended up doing a term paper on the John Steinbeck novel, The Grapes of Wrath. Okay? Seen the movie, read the book, loved the book, wanted to talk about that. And even as a little nerdy kid, one of my heroes was a guy named Ralph Waldo Emerson. Love him. Okay, some of you guys are nodding your heads like you know who he is, right? And so I had kind of come up with this concept about, in the paper about using some of Ralph Waldo Emerson's ideas and applying them to certain things that were in the novel, right? Now that I can get more technical about it, but long story short, I did this term paper, pretty proud of it. And so I ended up turning it in to a student teacher that was sitting with my regular English teacher. And he was the one who got to do, as a part of their program or whatever, got to grade the papers on that. And so I got my term paper back and I got C-. And that was devastating to me. But the worst part was that he had written a note at the very end of it. And he told me, like, there's no way that you came up with these concepts. You need to be able to talk about whose concepts these are. And that's why I got your grade. So of course, that's sort of akin to like plagiarism. So I had to be brought in, talk to the regular teacher, talk to the student teacher, and I can remember that feeling. Saying, just kind of nod your head if you can kind of understand what I'm talking about. A little kid, my face felt hot, had a dry mouth. I didn't know what to say. I didn't know how to react or what the right thing to say was, because I was being faced with an allegation or an accusation I didn't do. And so I would have really appreciated maybe having a parent there, having somebody there to be able to talk to, somebody there to explain what I could say in reference to that, because I don't have any good experience with that. And you better believe I would have wanted to have them have the burden to prove this allegation against me. Now, after that meeting, my parents got involved, and of course, they sort of turned everything around for me and ended up working out just fine. But I never forgot that feeling. And everybody here that can nod their heads who's been accused of something they didn't do, I'm sure can understand. That is an awful, awful thing. And so what you guys are about to embark on, especially if you make this jury, is one of the greatest, most awesome experiences and concepts in this country. To me, personally, the single thing that makes it the greatest, and that is the ability for people, just like LILIAN, to sit down and scrutinize evidence that's brought in accusation by the agents of the government and say, and decide it to the best of their ability and say, prove it to me. Prove it to me. Prove it to me beyond a reasonable doubt. Again, we can't define what reasonable doubt is, but like everything else that you bring to the table when you walk in, you get it. You have a doubt. You can make a decision as to whether it's reasonable or not. It was an example about aliens or something like that. We know that that's not reasonable, right? Unless you literally have video of an alien invasion or something, right? But you can have that. You scrutinize. You do it all the time, right? And so I'll speak to you, sir. What was your card there? Okay, juror number 6. Have you ever bought a vehicle before? Motor vehicle. You went to a dealership. Okay. I'm sure that's most people's experience when they purchase one. How would you feel if you saw the car on the lot, you liked the way it looked, and so you went up to the guy that was on the lot working for the dealership, and you said, "I'm interested in this car," and you start asking questions. How does it run? Can I test drive it? Those are questions that you would want to ask. Is that right? What would you say, or how would you feel if he said, "No, take my word for it"? You start to doubt their integrity. That's right. Now, if he was to tell you something like, oh, no, she's a beat, she runs great, she's, she's smooth, all of those things. It sounds nice, right? But what would you want? What would you want to see or know? And then there's no wrong answer.
Like to drive it, to look at, go inside, sit in it, and judge for myself.
Okay. Now, I hate to be, just asking you guys to lift cars and not lift cars, but does anybody here disagree with what he would want to do if he bought a car? Would just take someone's word for it. Raise your card. Okay, good. No one has to raise their cards on, right? Okay, so that's important. And what it really means is you take that presumption of innocence that I talked about, right? And you apply it to the case the state is putting on against LILIAN. Okay, you do that type of thing. That's what we do every day. It's not like it's not some super complicated thing. You look at it and you say, okay, is this really proven to me? And that's a high burden, right? You can come up with doubts and say, I'm not sure, And so I have a question for you, or I have something I need to talk about, which is, where can reasonable doubt come from? It can come from the lack of evidence. It can come from evidence that's provided to you that you don't believe, or evidence that's provided to you that you think is just not enough. Okay? That's how life works, right? So you can basically look at an entire case, the state can rest, and you can say, it's just not enough. And so, ma'am, if you raise your card in the book, juror 12. If the state brought evidence to you, let's just say it's 20 witnesses, but you just have doubt in your mind about the credibility of each and every one of them, just things in your head that bother you. What would your verdict have to be?
Just the second that you would check based on completely defined beyond reasonable doubt, and it's a limited question.
That'll be overruled.
I'm sorry, you can proceed. I'm sorry, I didn't mean to put you on the spot. I just got.
Still answer the question.
If you can, yes.
Probably depends on context, but yes, there's a burden of factor.
I'm sorry, pardon?
And if they have a burden of proof, so yes, I would consider the context.
And so, Mike brings up a good point here. I should probably describe this a little bit more thoroughly. As LILIAN sits here, okay, she is presumed under the Constitution, under the law, innocent, right? Which means that you have to believe that as she sits here right now, you have to believe that she's innocent. Okay? Does anybody have a problem with that? Raise your card. Please. Okay. So the state, at this point, with that presumption, stood up and said, we rest our case, no evidence. What would your verdict have to be? Just you can call it out. All right. Anybody disagree with that? If the state put on a case with evidence that you had questions about, doubts about, what would your verdict have to be? Does anybody have problems with that? Please raise your card. Can I get some cards up and say, I'm going to hold the state to their burden? Which we're going to talk about in a bit, but I'm going to hold their state to their burden. Raise your card. Everybody that does that. Okay. The burden. What is the burden of the proof that they need to prove this case to a jury? I've said it a million times. It's beyond a reasonable doubt. Okay, that is the highest burden in the land. It is an awesome, incredible, revolutionary concept when it was put into our Constitution. So there are, to kind of give it some context, there are a couple of different burdens of proof that are in the law. The lowest that I think I've ever heard of is something called a scintilla of evidence. A lot of times that shows up in like civil or administrative cases where you have just some little something of evidence to be able to proceed, let's say, on a lawsuit without just getting it dismissed, something like that. Higher than that, you have one that is talked about a lot, which is called reasonable suspicion, which is enough evidence for an officer to detain you and investigate you, okay? And reasonable suspicion is an officer being able to speak to some articulable specific facts. I can say, I need to be able to investigate further, okay? Again, not reasonable doubt, okay? The next one that a lot of people have probably heard about is probable cause, okay? And that is the evidence that is needed to place someone under arrest, to get a search warrant, something like that, okay? And that is a specific amount of evidence that would be needed in order to show that it's likely that or very possible that a criminal offense has occurred and someone needs to be detained or lose some aspect of their liberty, okay? Now, in civil cases, there's a burden of proof called preponderance of the evidence, which means more likely than not. 51, 49% is the way a lot of people say it. And that's how you prove cases like that. Chris Boyd brought up a good one that I think a lot of people, it's like food for thought for a lot of people, which is something called clear and convincing evidence, okay? Now, that is the standard of proof that the government needs in order to initiate termination proceedings for somebody and have their children removed from them. Now, a lot of people ask this question specifically, but I venture to say that everyone here who has children would want a whole heck of a lot of evidence in order to take their children away from that. Does anybody disagree with that? Now, even then, even at that standard of proof, it's not beyond a reasonable doubt. Beyond a reasonable doubt's the highest. It is the one in which somebody's liberty is taken from them. That's their rights as listed in the Constitution, right? Rights that come from nature, God, whatever it is that you don't, they're given to you on the day you're born. In order to do that and have 12 people make that decision, it's got to be the highest. Please raise your card if there's anybody here who feels that they cannot sit in judgment under that standard. And please raise your card if you don't think that that's fair to have that high of a burden of proof in this type of case. Thank you. I think it is important to talk about the right to remain silent, which we have talked about a little bit, but let's talk about it a little bit more. Now, we talked about it being the state's burden. They take on that burden when they bring the accusation. We talked about my situation, your situation, sir. Other people talked about being accused of something they didn't do, right? And then it's the state's burden in this legal system to prove their accusations, right? That burden never ever shifts to the person that is being accused. They do not have to prove themselves innocent. Does anybody have a problem with that? Now, sort of connected to that is the right to remain silent. Now, if someone chooses not to testify, put on a case, prove themselves innocent, none of those things, if they make that decision not to do that, that cannot be used against them. That is a right that they have. That's listed in the Constitution. That is the law. I will ask you, is there anybody here that feels that in order to come to a verdict on this case, that you would need to hear from the accused? raise your card. Raise your card if, in your heart, you know it, you haven't explained the law, that in order to come to a verdict on this case, that you would need the defense, the defendant to put on some type of evidence in order to show you something. Prove herself in some way, shape, or form innocent or not guilty. Raise your card. Does anybody have any questions at this point?
That's true. 5 minutes.
It is okay. Anybody have any questions at this point? Want to talk about something that's important. Michael talked about self-defense with you guys. He explained the situation. I think everyone's kind of talked about that, but I want to bring up just a real quick example. Maybe some people have heard of this this type of story. It has to do with the movie star Bruce Lee. Okay. There's stories out there, maybe you've heard them before, that when he was younger, and maybe he'd been picked on when he was younger or what have you, he got trained in martial arts and he showed himself to be pretty darn good. And then after a certain period of time, he started to get really confident. And one of the stories is that he would dress like a square, like a just like a sweet boy. Maybe in your head you think of like a sailor outfit or something like that, in order to goad people into messing with him, picking on him, doing those things, almost as a way of provoking people to mess with him. And then when it happened, he would use his skills in order to do that. Now, in that type of situation, who here says that Bruce Lee is the innocent person if someone picked on him based on what he was trying to do? Anybody? You see, that's sort of the idea when it comes to people coming in here and looking at evidence, listening to evidence, judging credibility, all of those things, is to ask yourself those types of questions. Is to really think through things and say, does this make sense? Because a lot of us have seen it all, right? I've seen all kinds of things that you wouldn't believe when you were young or whatever. And that's why you get to be here. And when you deliberate, you get to talk about those things. It's very important. Don't ever please let go of the things that you think, your beliefs, and your sense of what the state needs to prove to you in order to reach that burden of beyond reasonable doubt.
All right, state 16 minutes.
Judge, can you let me know when I have 5 minutes left?
Yes.
Thank you, Judge. No, can I get the So I was rushing in, so I want to make sure I have time to cover a couple more concepts. First, a couple wrap questions. Is there anybody here that cannot sit in judgment of another person, whether that's religious, moral reasons? Number 1, you can't sit in judgment of somebody?
No, I feel we are not, there's a higher power than us. We shouldn't judge people if they're guilty or not guilty.
Okay, is that based on like a religious, moral?
It's just moral, it's just,
Okay.
whatever.
So having that feeling or that sense of morality, if we were to be on this jury and you were to hear the evidence and the judge would give you the law, would you be able to apply the law to the facts and render a verdict?
I think it would be hard.
Okay. It's one of those questions like I gotta get a yes or no. It's like a pregnancy question. I know it's just
If the facts are there, evidence is there, then, but not just because everybody feels entitled one way, then.
so yes, you could apply the law to the
Yes.
facts. Okay. Sorry, it's just one of these things that I can do. 9, can you explain that? Not my place. Not your place. And same question to And same question to number 1. If the judge were to keep the law, you heard all the facts, would you be able to apply the law to the facts and render a verdict? One of these things I like, I can or I can't. Not that you don't necessarily want or it's not right to you. Okay.
No.
Anybody else? Does anybody know who anybody's been accused of this crime or a similar crime like assault or family violence generally? Let's see, several cards up. Out of those people who are raising their cards, does anybody feel like that person wasn't treated fairly throughout the process? Turn number 42.
Yeah, they were treated fairly.
Okay, they were treated. Does anybody hear that they were not treated fairly? Others who raised their cards. This is a loaded question, and there's probably a lot of responses, unfortunately, due to the rates in our community. Does anybody know anyone who's a victim of this crime or similar crime, family violence? So I see lots of cards up. Out of those people who are raising their cards, does anybody feel like that victim wasn't treated fairly through the process? Number 15, you feel like that person was treated unfairly? And juror number 16. And juror number 48. So this question goes to 15, 16, and 48. Out of you 3. Oh, I'm sorry, 57. Thank you, juror number 65, team player. Out of those 4, 1, 2, 3, 4, yes. Knowing that, would you still be able to be a fair and impartial juror in this case? Having set aside that experience or knowledge, be able to look at this case, get the law from the judge, apply the facts to the law, and then render a verdict. Juror 16, you would. 15, 48. Is that a yes? Yes. That's a yes. And juror 57. Is there anybody, judge covered a lot of these reasons, and these are not any reasons that the judge has already talked or you spoke to the judge about. They can't sit on this jury for any reason, health, hearing, language issues. Jury number 23. Is your talk to the judge about it? That's health. Health reasons. Are you comfortable talking about insurance or not? Is it, try to be cautious. Is it, are you able to sit for long periods of time? Yeah. How long are generally you able to sit? We might be able to make accommodations for that. Turn number 51. Turn 51. What is it? Health. I'm sorry? Medical. Medical reason? Yeah, I have an operation. Okay. Is there anybody here who believes that they cannot be a fair and impartial juror on this case with everything that both I and defense talked about, or any reasons that we did not discuss? It's not my last question. Generally, does anybody have any questions for me? So I have some individual questions for some of them. I know you probably saw me looking through some papers. That card that you filled out, you get a little copy of it just to see what's going on, and we're able to just answer some good questions or answer questions based on those. Juror number 4. You noted that you were either accused, complainant, or witness on a criminal case.
I don't mind.
Yeah, were you accused?
I was a witness.
A witness? Okay.
Not in court.
That's fine. And you know what kind of case was it?
I can talk about it.
I just.
It was a jewelry store. Someone robbed us, and
I'm sorry about that. I didn't mean to trigger you with any robbery. Good to know. Learning experience. Juror number 31. You know that you were just on a criminal case? No. Okay. No worries. This probably do this. Juror number 35. You know that you were accused of a case. Accused of complaining or it's a victim or a witness.
I turned somebody in.
Witness. Okay. Thank you. Juror number 5. You been on a criminal jury before? What kind of case was that? Wow. Okay. When was that? 20. And in that case, did judge or jury decide punishment? Very good. Juror number 11. You were also on the criminal jury? What kind of case was it? Man, that was a heavy case. Did the judge or jury decide punishment?
The judge, we convicted him, the judge.
Juror number 19. Same question. You on the criminal jury? And what kind of case was it? Oh, depressing. Did judge or jury decide punishment? Juror. Juror number 30. Criminal jury, right? What kind of case? Solicitation of a minor. Did judge or jury decide? Jury did. Thank you. Juror number 33. You were also on the criminal jury? Yes. What kind of case was it? Fine. I was waiting for something dark. Did a judge or jury decide that? Judge. Thank you. Juror number 45. Criminal jury? Yes. What kind of case? Narcotics distribution. Narcotics distribution? Yes. Did judge or jury decide that? Thank you. Juror number 46. Criminal jury? Yes. What kind of case? New York. Okay. This front end was heavy. Did the judge or jury decide punishment? Judge, thank you very much. And then juror number 63. Judge, okay. Thank you, everybody. Out of all those ones I asked about juries, did any of you have any issues reaching a verdict? Or I try to take all of that. Don't even worry about that question. I'm gonna move on. Juror number 54. I don't have a response form for you. Were you ever served? Did you ever serve on a criminal jury? No.
All right, so I'm gonna need juror number 54. I need you to speak up so that a court reporter can hear.
Okay. And have you ever been an accused, complainant, or witness on a criminal case? Okay. And what do you do for work? Seller. A seller. Okay. So what do you sell? Maybe I want to buy.
Anything that makes profits.
Oh, okay, all right, entrepreneur, right? How do you pronounce your last name? Good. Thank you very much. Juror number 66. Ms. Allison.
She's sick. She may be the worst.
I'll move on. 5 minutes. Thank you, Judge. Okay. Again, this is the last time you to ask me any questions until this is over. Does anybody have any questions for me? This is the first of a room of 75. Okay. Thank you, everybody, much for your time, and we'll look forward to seeing both of you all in the next couple of days. Thank you. Thank you, Judge.
All right, thanks.
Right.
talking here for just a moment, and I apologize. But regarding some of the questions that were asked to the state on the witness complainant or accused, the juror 4, I believe you had raised your card, is that right? You had raised your card with the question that had to do with whether you were a witness, complainant, or accused. What was your role? I'm sorry, but
I was witness.
you were a witness. Sorry. And that was a criminal allegation. And but you were not the complainant in any way, or it's another word for the state would say, or people call victim. But were you victimized? Was there like a crime that was perpetrated upon you?
No.
Okay. Okay.
I'm the one that saw the robbers.
I see. Thank you. And then I think juror, I also missed, and I apologize again. Juror 31, raise your card. Yes. Were you a witness as well, or?
No, I have someone close to me who was recently assaulted, so I think when I read that question quickly, I put yes,
Okay.
but I was not.
And so I guess I should ask you regarding that closeness that you have with that person. Do you feel that it would affect your ability or to be a fair and impartial jury in some case?
No.
Want to talk a little bit about the all you guys kind of fill out little questionnaires, you have little forms and stuff like that. Of course, that's stuff that we look through to maybe figure out how to ask you guys questions. There's a good number of you that have some sort of relationship or have worked within law enforcement. Those people that have had that, can you raise your cards, please? I'm sorry, people that on the questionnaire had said that they're related to someone in law enforcement, a loved one, someone like that, or maybe they themselves worked in law enforcement. Could you raise your card? Okay, I'm going to call this out. 2, 11, 19, 23, 22, 30, 34, 42, 50, 59, 61, 62, 65, 66, 67. Oh, and 42. Thank you. Of those people who raised their card, please raise your card if you feel in your heart that being close to someone in law enforcement, having that closeness, that would make you tend to be maybe more partial to, maybe even have a bit of a bias toward any type of law enforcement witnesses. Raise your card. Juror 11. Anybody else? Juror 67. Juror 23. And I'll ask you, man, because I have to, on regarding that, feeling you might be a little bit biased toward law enforcement or anything like that. Do you feel as you sit here now that that's something that's within you, that you would be more partial, having heard nothing, but just because of your experience, you'd be more partial and have a bias toward the state of it?
Yes, my son-in-law is a police officer on the east side. So take his word for it.
I appreciate your honesty. Thank you. Thank you. I appreciate that. Who else raised your card? Juror 23. Could you explain?
Just close family member, but also go to the evidence and people. So if it's the person telling me something, then obviously I will follow what you're saying. But in this case, I will, follow.
And so you're saying that you'd be able to scrutinize the evidence, listen to it as it's put in front of you, and that it is just not like you're not going to give some extra bump for someone that had just because they're an officer. Okay. Next card, 42.
I was the first woman police officer in 1976 in Wichita, Kansas.
There you go. That's awesome. That's really awesome. Do you feel because of your experience in law enforcement?
It will make a difference. I will scrutinize the evidence a lot more.
Excellent. Excellent. Thank you. There's another card that was up regarding that. I think I saw it over here. Raise your card. Anyone on this side? Juror 67. Yes, sir. Can you explain?
I'm Scott.
And because of that closeness with your family member and their role in law enforcement, do you believe that you would give some sort of extra partiality, maybe just a bit of bias?
Yeah, like I think the authority of their position lends to the credibility.
I can't, I'm sorry, Mr. Bart, you're blocking him and I can't hear you, sir.
My apologies. I think their credibility would be extra as a member of law enforcement.
Thank you, sir. I appreciate that. And so you say, as you sit here now, having heard no evidence, you feel like you still, if you receive someone with a badge, a police officer, you would give them some sort of extra credibility, more so than like a regular juror or a regular witness. Okay. Anybody else?
I didn't hear his answer.
Oh, you said, sure, but go ahead, sir. Could you say that again, sir?
Sure.
Oh, I'm sorry. Do you have questions?
Yeah, I gotta bring this up. My job is I review evidence that's given to the state for what they call violations in civil in the code for facilities that
Well, I missed that last part.
nursing facilities, et cetera.
I see.
I review the method. The result is that's been very heavy in my job right now, and I'm concerned that I may put more the opposite side, instead of giving them more credibility, I might be.
Okay. Now,
Meaning I would expect a lot. Every job should have every time.
okay.
So
Now,
that's what that's bringing it to attention, because we want to take it out of that. Yeah.
and so I guess what you're saying, and I'm gonna ask you to kind of explain, it's because of the job that you have where you have to scrutinize evidence.
Right.
Is that right? That you would hold any witnesses, law enforcement or whatever to a very high burden.
I would expect the evidence to be very well played, yes.
Okay. And so I'm gonna have to go back to this question that Michael asked, which is, do you believe that it would be, that you would need to have some degree to be on all doubt or beyond a reasonable doubt?
Probably with the, my answer may be a little weird. Because I'm having to go by the letter, I would have to say all that.
Yeah, all doubt. Okay, and I guess I have to ask just really quickly, why it is that you feel that way?
Because I have been seeing significant amounts of very poor reports that are easily to be looked at and wondered about, and they can be completely turned around as a result of that. As a result, I am becoming very, very focused on that.
So I'll have to ask you this question. If somebody takes, if a witness takes the stand for the state, they happen to be law enforcement, and you feel, if you were to make the jury, you feel that they've shown you, and you believe that they've done their job correctly, they've done everything that you would expect as a citizen, are you saying that you would still not be able to believe it?
I'm not saying I'm not really able to believe it. I'm saying I would hold them to a higher standard.
Okay.
Than I would somebody who's not.
Okay.
That's.
Fair enough.
It's a reversal of the way that you asked the question. Would you hold a police officer, give them a vote? That there can be evidence? No,
Yes, sir.
I'm afraid that if it's a person of court, I would be scrutinizing it.
I see. Okay, fair. Thank you, sir. Anybody else want to add to that, chime in, anything like that? Please raise your card. You brought up a good point to me. I think it is important to ask this question. I'm sure a lot of people raise their card when they said lawyer shows, things like that. Okay. Now, while in my experience, it doesn't always go sort of that way. Part of what we have to do is ask very tough questions. There's something called cross-examination. I'm sure a lot of you have heard of that, where you're sitting there and you're trying to run people's testimony through a magnifying glass, trying to ask very pointed very important and direct questions, and sometimes that can come off tough, okay? That's part of, as I mentioned before, everybody doing their job to the utmost ability. Now, please, if you feel like, if you raise your card, if you feel like, if you see us having to ask tough questions, having to scrutinize things, having to even, go through a concept or something like that, that might seem even harsh to ask those questions. Would you hold it against Liliana? Would you hold it against me or Neil, or even the state for doing it? Raise your card. Thank you, everybody.
All right, ladies and gentlemen, the jury, I'm going to have you step outside in the hallway, and then we will bring you back in shortly, and we will let you know who is going to be seated on the jury. Before you all rise and leave, make sure you take all of your personal items with you. Even if you're sitting in the box, take your personal items with you, but leave the cards in the chairs. And if you could wait out in the hallway, because again, we can't finish until everyone's outside in the hallway. Harold, rise for the jury. service. Excuse me. Hi, excuse me. All right, everyone, thank you so much for your service. As I call your name, I need you to take a seat in the jury box. You will be on the jury. Isha Muhammad. Robert Smith. Mr. Tran. Or Miss Tran, I'm sorry. Who is Thawan Tran? How do you pronounce your first name? Diane. Diane. Manuel Garcia. Jacob Nunez. Mincy Rodriguez. Eric Rodriguez. Stephen Madrano. Lilia Cintron. Suzanne Urban. Deborah Tope. Mark Rodriguez. Mia Garza. Cynthia Ruiz. All right, to everyone who was not selected, again, thank you for your service. You have the square pieces of paper. You'll need to take those downstairs if you want to turn them in, and you can actually donate the amount that you will be paid today. You can donate to different organizations. They'll let you know which charities they're available to donate to. Or if you want to not donate it, probably 2 months from now, you receive a check in the mail and you'll be shocked and surprised, and it should be enough for you to actually buy lunch with. So everyone, thank you so much for your service. The courtrooms are always open to the public. So you're more than welcome to stop by and see what happens in the 187 District Court and other courts. Yes, someone raised their hand in the back. Sorry, what are you holding? They will take you down and let you know where to be for it to be validated. Usually it's validated in the basement, but I believe they may be closed. Is that correct? Yes. All right, the deputy is checking on that, but we'll make sure that that gets validated for you. Is there any other questions? All right, thank you again for your service. You are excused.
For those of you that like your ticket validated, make sure that you have your little paper or your juror sticker. Let them know you were at the 187 doing your duty. Those are excuses for work at school. Or go on retired. Do you need one? Is that we turn that in to get? That, no, if you have not, if not to let them know that you were at the 187.
Somewhat when we were supposed to fill out a form donating our, just mentioned donating our.
Oh, if you take it downstairs and let them know. Thank you.
Do you need one? That's just excuses for work and school. Work is good. Take a spot.
All right, ladies and gentlemen. As you can tell, it is extremely hot in the courtroom. I sent several emails for 2 weeks now. Sometimes though, it's extremely cold in this courtroom. So you never know what you're going to get as far as temperature is concerned. So I always tell everyone to make sure that you bring something warm, because you can always take the jacket off. I do allow people to bring water. If you want to bring water or bring your coffee to drink, you can. Just make sure there is a top on it because we've had spills in the past. We're going to start with with testimony and evidence tomorrow at 10:30. I'm starting at 10:30 because there are other cases that I must take care of. And again, when you see me doing other things, it's not related to this case. Here's the thing about us starting at 10:30. We can't start at 10:30 unless everyone is present. Does everyone understand? I don't expect this to be on the news or in a newspaper or anything of that nature, but if you see anything regarding this case, do not look at it. Does everyone understand? No one is allowed to do their own investigation. Don't do that. Does everyone understand? The evidence that you receive in this case will be from this courtroom through the witness stand or through exhibits. Does everyone understand? You are not to talk about this case amongst yourselves. You're not to talk about it with family members, okay? All right, does anyone have any questions? Yes,
So court starts tomorrow at 10:30 a.m. Does it run the full day?
yes. And what I try to do is I try to make sure that jurors are released by 4:30. That way you'll beat the rush hour traffic. Today, as you can see, it's almost 5:30. That's a good thing because you're going to avoid rush hour traffic. The other thing, if any of you ever need a break, it's difficult for me to see the jury box because we have the computer here. This is where they placed it, and we have one here. Just raise your hand, either the state or the attorneys for the defense or the deputy, and Brenda, who has eyes in the back of her head, will see you. And that'll be a signal for me to give you a break. Okay, so don't hesitate and raise your hand if you need a break. Also, if there's something that you can't hear, let us know that you can't hear. We will have witnesses come in and we try to have the microphones loud enough for everyone. When you come tomorrow, you will not be reporting to the courtroom. The deputy will show you where you need to report. If you want to bring food for lunch, you're more than welcome to do that, and it will be safe and secure. Well, we say secure in the jury room, but the jury room is secure. But you can bring that and have your lunch here, okay? And if you want to come before 10:30, you're more than welcome to come before 10:30 and wait in the jury room. And if you want to bring your breakfast early, you can. Our court starts at 9 a.m., so I will be doing other things, and the deputies are usually here at 8. And I'm usually here at 8 anyway. So if you want to come early to be already in the jury room, you can do that. All right, are there any questions? Yes.
I have 2 questions. One question is, do we know like breaks for tomorrow, if there are any? And then the second question is, do we know if it's longer than tomorrow?
We will see. Trials have a life of their own. So we will see how things progress. Now, what I will tell you, if there is some reason for us to go longer, I will talk to you all about that, okay? And of course, everything that I discuss will be in the presence of the state and the defense. But we are anticipating that this trial may or may not conclude this week. Any other questions? Yes.
And the break. Which one?
Oh, you just raise your hand if you need a break. Yes. Yes.
Can I get rough know what the extension is, so I can print them at work?
We'll take care of that.
Okay.
Yes.
Your Honor, I had informed you that tomorrow, my mother's funeral is tomorrow.
What time, sir?
It's at 11:45 at Fort Sam.
All right, just give us one moment, okay?
Okay.
All right, could I have attorney's approach, please?
Do you want the noise?
Yes, please. Definitely need the audio.
I think we'll do it.
Just have to turn the audio. Other than, and your juror number was, sir?
14.
All right, other than juror number 14, is there any other questions? All right, everyone, the deputy is going to show you to the back where the jury room is. And remember, that's where you report. And remember, we can only start if you're all here at the same time, okay? All right, and juror number 14, if you will remain behind, please. Everyone, please rise. All right, everyone, please be seated. Juror number 14, I'm so sorry to hear about your mother's passing.
Thank you. She actually passed away 3.5 weeks ago, but because of the backlog in the court town, until tomorrow.
Okay.
Tonight is the rosary.
Okay, well, what time is the rosary?
At 7.
All right, so we're gonna excuse you so you can make sure you make the rosary, okay?
Okay.
All right, so I had a discussion with both the state and the defense, and we're gonna excuse you from the jury.
Okay.
All
Thank
right.
you very much. I appreciate it.
All right, you're welcome.
Thank you.
And you can go downstairs. The doors are still open, so you can still go that way. Remember, if you need the validated parking, just let them know you were in the 187 District Court.
Thank you so much. Appreciate it.
All right, thank you.
Thank you very much.
All right, so everyone, we're gonna start up tomorrow at 10:30 a.m. If there are any type of motions that need to be heard or something that needs to be heard before then, I'm gonna ask that you all be here at 9.
Yes, sir.